to the negotiations because that's not the time to do it. I also don't want you to say anything on the record right now that would potentially hurt you later in a trial. Okay, so what I need to know is, sir, you're Lester Bolard? And Mr. Bolard, in cause number 24, DCCR 1882, you're charged with a second-degree felony offense of aggravated assault with a deadly weapon. That's from July 8th of 2024. Your indictment alleges that you were previously convicted of the third-degree felony offense of stalking on June 11th of 2007, and after that was final, you were convicted of the third-degree felony offense.
At this point, the judge lays it out. Lester's not just facing one charge. With his past felonies, he's now a habitual offender. Translation, 25 years to life if convicted. One wrong choice here could seal his fate.
Of assault with bodily injury on a family member, and that's from October 22nd of 2010. What that means is that if you go to trial and you're found guilty and those two prior convictions are true, then you would be considered a habitual offender with a minimum punishment of 25 years up to 99 years or life in prison. Do you understand?
Yes, ma'am.
And I have here on the computer a plea bargain rejection that has your signature on it with Mr. Parker's that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty. And that would be on count one only. To count one only, which is the second degree felony aggravated assault that you're charged with. And it would be for a cap of 5 years in prison, which means you would be leaving your punishment up to me. I couldn't give you more than 5 years if I accepted that plea agreement. I could give you 5, I could give you less. It would depend on the information that was brought to me at a sentencing hearing. You have every right to reject that and have a jury decide if you're guilty or not, and then let them decide your punishment. I just want to make sure you understand what the possible consequences are if you go to trial and what your options are. And do you understand all of that?
And when I was speaking with him, I didn't want to sign it until I spoke with you.
Okay.
And sign it, he was going to tell you that I rejected it.
Okay.
That's why I wanted to speak with you to get a clearer understanding.
Okay. All right. What do you not understand?
I wanted to get a clear understanding of speaking with you about it.
Okay.
Because there was somebody that pulled a gun on me.
So hang on. Here's the thing. I'm not going to talk to you about the facts of the case. All right, so that's what your attorney's for. That's what a jury's
I relayed
for.
all this information to the district attorney's office, and they're aware of all this stuff.
Okay, so Mr. Park, you've told him these things about what happened. He's told Mr. Smith. Mr. Smith's made his offer. You can either take it or let a jury decide. We're not going to negotiate. I'm not going to get into the negotiations because that's not the time to do it. I also don't want you to say anything on the record right now that would potentially hurt you later in a trial. Okay, so what I need to know is, do you want to accept that plea agreement for a cap of 5 years, or do you want to let a jury decide?
This is where the real pressure hits. 5 years guaranteed or risk life in prison. The judge isn't sugarcoating it. Don't plead guilty unless you did it. What would you choose?
If you didn't do it, that's what juries are for, right? Okay, so you can't, if you plead, here's the thing, if you want to plead guilty, you're going to swear under oath that you're telling the truth. I'm going to ask you the question, are you pleading guilty freely and voluntarily? Are you pleading guilty because you did it? If you didn't do it, then that's what a jury's for. So do you want to reject that offer and go to trial?
I was asking about the speedy trial as well.
So we do not have any type of backlog here in this court. Cases are getting tried as quickly as we can possibly try them every single week. So every trial gets as speedy trial as I can possibly give it. All right?
Reason why I say, because I'm around people say they've been there 2 years in the county.
There are different things in different cases that cause them sometimes to go longer. Sometimes it's a different court. Sometimes it's just the facts of the case. Sometimes it's DNA. But I can assure you that we will do it as quickly as we possibly can. All right. So do you want to reject that offer and go to trial, or do you want to accept the offer?
In between now and whatever the speedy trial
I don't get to. No, here's the thing. After today, if you place your case on the trial docket, My trial docket isn't somewhere where I put cases so that there's some more negotiation or you get a lesser deal later. Today's the day if you want to take a deal. If you don't, if it's on the trial docket, your choices are either going to be to plea open to me or to take it to trial. Because that's how I keep my trial docket moving so that it doesn't get too big and people aren't waiting on trial for a long time. Mr. Smith, is there any reason to believe that that offer would change? Okay, so the offer is what it is. Take it or leave it. What do you want to do?
I'll take it.
I want to make sure you understand what you're going to do and say on the record, however.
Yes.
Okay.
There's no, so I might as well take it.
No, there's no might as well take it. Either you did it and you're guilty of it, or you let a jury decide. You're not going to stand in front of me and say, I didn't do it, but I'm just going to take a deal. It doesn't work that way. I can't allow you to do that. Go talk to your attorney about it and y'all let me know what you want to do. I'll hold it for now. Good morning. You're Preston Fontenette? And Mr. Fontenette, you were previously in court and entered a plea of guilty to unlawfully possessing a firearm by a felon. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
Yes, Your Honor, I have.
Yes, Your Honor.
Are there any additions or corrections?
Not from the state, Your Honor.
No.
Okay, so Mr. Fontenette, in this pre-sentence report, you stated, I didn't really commit a crime at all. I didn't do anything at all. So if you didn't do anything and you didn't commit a crime, why did you plead guilty when you were here before?
Feel like didn't have a choice.
Okay, so are you saying that you did not reach into your waistband, pull out a black object, drop it on the ground, and then kick it underneath the car, and it turned out to be a black Glock 43X 9mm? You didn't do that? Okay, then I'll reject this and we'll get your case set for trial. I will not accept any plea agreements. You'll go to trial or your plea open to me. You can go back with the bailiff. All right, sir, are you Lentavius Strickland? And Mr. Strickland, you were previously in court, entered pleas of guilty to evading arrest or detention with the use of a motor vehicle, as well as unauthorized use of a motor vehicle. I've received the pre-sentence report and reviewed that. Has everyone had an opportunity to review that?
Yeah, Your Honor.
State has, Judge.
Are there any additions or corrections?
None more, Judge.
Not from the state, Judge.
In addition to that, I have reviewed your jail incident reports. Everyone's been given a copy of those as well. Have y'all both had an opportunity to review those?
Yes, Judge.
I have, but I don't remember.
4 fights.
Yeah.
Oh, yeah.
You like to fight, don't you? You don't? You don't? Okay. I can tell you that I have people in front of me all the time, and they're not doing what you're doing, constantly fighting. And the way these reads, it does not necessarily show that you weren't the aggressor. It doesn't show either way on some of them, but it looks like these were some pretty mutual things going on, specifically finding places to fight, getting in the bathroom to fight so you can't be caught and all that kind of nonsense. How old are you? 19 years old. So here is where I am on this. I understand that you guys had agreed to the 180 days up front. I don't know that jail necessarily is as useful as potentially something like ISF, cognitive track, because of its age, nature of the offenses, and what's going on in jail. The only way I'm going to go along with this agreement is to try to get you in a better place to make better decisions so that you can be successful on these probations. I want you to be successful. We all do. But at the rate you're going, you're not going to be. The conditions of your probation are always up to me. So I can give you what I want as a condition, anything that makes me feel like it would be helpful for you, helpful for the community. So what I'm going to do at this time is find that you previously entered your pleas of guilty freely and voluntarily. And cause number 24 DCCR 2440 finds sufficient evidence to find you guilty, and at this time, follow your agreement and finds you guilty of evading arrest or detention with the use of a vehicle. Sentence you in accordance with that agreement to a term of 10 years in prison, but probate that. You'll be on probation for 10 years. You're ordered to pay a $1,000 fine and to follow all of the rules and conditions of probation. In cause number 25, DCCR 0209, find sufficient evidence to find you guilty, and at this time, follow the agreement, find you guilty of unauthorized use of a vehicle, sentence you to 2 years in the state jail prison, but probate that. You'll be on probation for 5 years in that case. I don't have a fine. Is there no fine in that one? The 1,000 and the others probably.
There was just one fine.
It was just
Okay.
one fine in one case, Judge.
Okay. So in each of these cases, you're ordered to follow all of the rules and conditions of probation. One of those conditions is going to be that you enter and successfully complete the cognitive.
A rare moment of leniency. Instead of prison, the judge sends him to a 90-day reform program. At just 19, this could be the turning point, if he takes it seriously.
Track of the ISF program. It's a 90-day program. It's in custody. You'll be transported from our jail to there fairly quickly. It's all about making better choices. Okay, so it's just to give you the tools you need so that you can be successful on this probation and not end up back in here and then going to prison. Do you understand? If you get in trouble now that you're on probation, if you get in trouble in the jail, get in a fight, if you get in trouble at ISF and you don't successfully complete it, you're going to already be in violation of your probation before you ever get out. So you need to figure out how to just stick to yourself, follow the rules, do what you're supposed to do so that you can get out and not go to prison, okay? All right, I'm handing you, and if you do everything you're supposed to, then for all practical purposes, your case here in court's over. You're going to serve those sentences while you're out on probation. But if you violate any condition of those probations, you'll be back in here and you'll be looking at the 10-year sentence and the 2-year sentence that you already agreed to. Do you understand? Okay, I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition or about how long that lasts, you can talk to Mr. Parker, okay? Good luck to you, sir. Take advantage of this opportunity. You can go back with the bailiff.